Hello there, it's September 1 and it's the first episode of the AskTheRealttorney Show. Now, today we will be answering the question that I failed to answer during my last webinar. And this is the question: can you legally sell the real property of a deceased person without settling the estate of that person? Stay tuned and find out. Now, last August 18, 2020, I spoke at a webinar presented by Prevail Inc. and sponsored by Carousell. Now, I had so much information that I was giving the participants that I ran out of time. So one of the questions that I failed to answer during the Q&A was from Brian Douglas Uiteng-Su. Shout out to you, Sir Brian. I hope you get to watch this video. So here's his question. Is it possible to sell a property where the title can be transferred to the buyer without going through the extrajudicial settlement, granting one of the owners or parents have expired? Now that is a good question because it is a frequently asked question. So it is a common question, especially being asked by accredited salesperson and newly licensed real estate brokers. So the answer is simply yes, it is possible, but it is very much illegal. So accredited salesperson and licensed real estate brokers should not participate in such illegality. So what can be done? When a person dies, by law, he or she passes on the assets and liabilities that he owned to the legal heirs. And that asset and liability is called the estate. Unfortunately, there is no definition of estate in the Philippines, but under sections 776 and 781 of the New Civil Code of the Philippines, those two articles define what an inheritance means, and I will read to you those sections. Section 776. The inheritance includes all the property rights and obligations of a person which is not extinguished by his death. Section 781. The inheritance of a person includes not only the property and the transmissible rights and obligations existing at the time of his death, but also those which have accrued thereto since the opening of the succession. Now, an estate is the total property, real or personal, owned by an individual prior to the distribution through a trust, will, or by agreement of the heirs. Now, we define real property as the one indicated in the law on property under the New Civil Code of the Philippines, mentioned as immovable. Now, personal properties, these include all things else, meaning vehicles, jewelries, antiques, expensive paintings, shares of stock, listed or unlisted corporations, insurance proceeds, UITF, bank accounts, and other securities. Now, we can consider that inheritance and estate as one and the same. So what passes on to the heirs, to the surviving heirs of the decedent, are what he or she will inherit based on those two sections. So can you legally sell the real property of a deceased person without settling his or her estate? Of course, now we know the answer. We cannot do it legally. So we must first settle the estate, then sell the property. So what does it mean to settle the estate of a deceased person? Now, the settlement of the estate of a deceased person is a process. So you add up all of the assets, real property, personal property, and minus the liabilities of the deceased person, so you can come up with a net estate value. RA 10963, which is the train law that was passed several years ago, reduced the estate tax rate from as high as 20% to a single digit of 6%. It is now equal to a capital gains tax when you sell a property. So that tax rate becomes more beneficial to those who want to settle the estate of a deceased loved one. How do you settle the estate of a deceased person? There are two ways, judicially and extrajudicially. We will only be talking of the extrajudicial means because judicial means is specifically limited to lawyers, and it's a very, very complex process which real estate brokers and real estate salespersons should not dwell into. So we will limit ourselves to the extrajudicial means of settling the estate. And what does that mean? That means that you have to contact all of the heirs. I mean all. Walang matitira. Lahat kasama. All of the surviving heirs, and let them sign a piece of document. And what is that document? That document would be your extrajudicial settlement of estate of a deceased person. Now, if there's a need to sell the property, so it will be an extrajudicial settlement of estate of a deceased person with sale. If you want to donate the property to a person, it will be an extrajudicial settlement of estate of a deceased person with waiver of rights. Now, if there's only one heir, then the document would be an affidavit of self-adjudication. But more often than not, all of the confusion and all of the conflict arises when there are more than two heirs. So, what needs to be done? Like I said, all of the heirs must be present and accounted for, and they must sign that piece of document. Now you ask me, attorney, bakit ho kailangan lahat? Hindi ba pwedeng yung pinakamalapit lang sa amin? Hindi po pwede. Because when you exclude one surviving heir, that is called preterition of heir. So, isinasantabi nyo siya, ini-echepuera nyo yung heir na yon. And whatever extrajudicial settlement of estate that you come up with without the presence of that heir, that pretreated heir, then all of that hard effort will be invalidated. So you are just inviting future litigation. So I am here as a lawyer and as a real estate broker. I am telling you right now that you should exert all efforts in order to get hold of the living or surviving heirs and let them sign that piece of document. If they're in the United States or in abroad, you could contact them through Facebook, through all of the social media applications, and let them sign a special power of attorney or whatever that document that is needed for them to consent to the extrajudicial settlement of estate that is going to happen here in the Philippines. So, everything must be done legally so that you do not invite future litigations from your relatives because they are also surviving heirs of the decedent. So to recap, we should first and foremost keep in mind that the sale of a property of a deceased person must always entail the settlement of the estate first. Then, after the settlement of the estate, the sale can proceed. Now, like I said, the sale and the extrajudicial settlement of estate can be combined with a single document, and this is the document that you will present to the BIR in order for them to compute the estate tax, which is 6%, and also the value of the sale, and in order to pay the capital gains tax and the documentary stamp tax. I hope this is helpful to you, and I hope you will exert all efforts to find all of the surviving heirs so that your real estate transaction of the property of a deceased person will be legal and will not cost you any money in the future in the form of litigation expenses. And if you need to ask further questions, just leave your comments below, and I will see you in the next video. Hey Realttorney TV viewers, if you find the information in the video very valuable, please like it, and most importantly, share with your friends or colleagues who you think will benefit most from watching this. Also, if you are a newly accredited real estate salesperson or a newly licensed real estate broker, then this channel is for you. It was made to give you free, practical, and actionable information in order to guide you into making actions and decisions as you navigate simple to complex real estate transactions. So please, subscribe to this channel, hit the notification bell so that you are informed of the new videos that we'll be uploading. Also, leave in the comment section the questions you need most answered to successfully negotiate and close your real estate transactions. See you in the next video. Bye for now. Stay strong, stay healthy. God bless us all.